So, very good evening, friends. Today, we will start with individual insolvency and bankruptcy. But before we take up the case studies on individual insolvency and bankruptcy, some of them I have shared with you also in the group. Let us understand the basic provisions regarding individual insolvency and bankruptcy. So, this is section-wise details and brief contents as to what is contained in which section. And this space for short notes, that is for you. So, you can make your own notes here. So it starts with the section 78 and it goes on to section 187. Some of the sections we already studied. I think we did up to 93. But let us understand briefly the process. In this case, default amount minimum is 1000 rupees, which can be increased by central government by way of notification up to 1 lakh. But there's no notification as yet. So the minimum default as of now is also 1000. In this case, application can be made either by the debtor or by the creditor. So there is no distinction between financial creditor and operational creditor as in the case of companies, as in the case of part 2. In case of part 2, we know that in case of CIRP, normally the application can be moved by the operational creditor or financial creditor or the corporate debtor. But here there are only two types of applicants, either the debtor or the creditor. Then another change is the concept of interim moratorium. In CIRP, there is no concept of interim moratorium, but here there is concept of interim moratorium, which starts from the date of filing of the application. There is a concept of resolution professional. So there is no interim resolution professional, no liquidator. So there is either resolution professional or bankruptcy trustee in case of bankruptcy proceedings. Normally, IBBI has so in some of the provision, in one provision only, 97.2. So you can remember that 97 in 97.2 only, IBBI has 7 days to revert. Normally, the period is 7 days and 10 days. In case adjudicating authority wants to appoint an RP or he wants to change an RP, so it will get in touch with the board and within 7 days, and normally the board has 10 days to revert. But there is only one section, it's section 97.2. So 97 you can remember like 7.2. So 7.7.2 times. 7 days for adjudicating authority and 7 days for board to revert. Normally it is 7 and 10. And then there is another difference that RP is required to make a report, whether it is case of this fresh start or individual insolvency. RP will make a report whether application is to be accepted or not within 10 days of the appointment. Then reasons, he has to give reasons for acceptance or rejection. Why? Because DRT doesn't have so much time to review each and every application because minimum threshold is very less. So a lot of applications are likely to come once these provisions are in force. So the RP has been roped in to check whether the application is to be accepted or not. So duty assigned to RP, and DRT within 14 days of receiving the report will either admit or reject the application. Of course, the opposite party has right to challenge it. DRT will send a copy of acceptance or rejection to RP, debtor or creditor within 7 days, and moratorium starts from the date of admission of application. DRT will issue public notice within 7 days from passing of the order in one English and one vernacular newspaper, besides publishing in DRT premises and on DRT website. The time for lodging the claims is 21 days. So within 21 days, all claims are to be lodged. And within 30 days, a list of creditors has to be made. So RP has got 9 days to make the list. So there is concept of list only and not COC. So there is no COC as such, but creditors meeting can be called in case it is felt necessary by the RP. And there is no concept of resolution plan. Like in part 2, in case of CIRP, we studied that there is a concept of resolution plan. But here, since the person involved is individual or partnership firm, there is only repayment plan as against resolution plan. So debtor will make the repayment plan in consultation with RP. And any modification suggested by the creditor also has to be approved by the debtor. Then justification by the debtor for approval of plan report on repayment plan. So by RP within 21 days from the last date of submission of claim. So he has got 12 days to prepare the plan and report, and RP will confirm whether the repayment plan which has been given by the debtor, whether it is in compliance with the various laws. So this is just a minute. Hmm. Hmm. So, and then RP will confirm whether there are chances of success of the plan, and RP will decide whether creditors meetings need to be called, which is to be called within 14 to 28 days of the report. Minimum 14 days notice period is required for calling the meeting, and creditors may either accept, modify, or reject the repayment plan which is put by the debtor. And for modification in the repayment plan, consent of debtor is needed. There are proportionate voting rights except in the following cases. For unliquidated amount, there is no voting right. If your name doesn't appear in the creditor list, there's no voting right. And associate of the person, which are basically immediate family or relatives of the person or the firm. So in those cases, they also don't have the voting right. Similar as in case of related parties, this related financial creditor, they don't have voting right. So similarly here also, associates, creditors whose name does not appear, and for any liability which is not yet crystallized, voting rights are not given. And after meeting, report is to be prepared by the RP explaining all facts, and report plus this repayment plan is to be submitted to the DRT. Final decision rests with DRT whether it wants to accept the plan. In case it accepts the plan, so it is binding on all the debtors and creditors. In case the plan is rejected, creditors get a right to sue for bankruptcy. And directly bankruptcy proceedings will not start. So first of all, insolvency and then bankruptcy. And once repayment plan is complete, report by RP within 14 days of completion of the plan. And in case of non-completion of plan or premature end of repayment plan, RP will make the report. And in that cases also, the bankruptcy proceedings can be initiated, and there is no concept of extension of time. So this is in brief the entire procedure of individual insolvency. Now let us see section by section. I think section 78 we saw yesterday also. The minimum default is not less than 1,000 rupees. So 1,000 rupees or more, but the central government may by notification specify the minimum amount of default of higher value, which shall not be more than 1 lakh rupees. But this is the minimum. Maximum could be anything. Then definitions, we saw the definition of adjudicating authority, associate of the debtor. So associate of the debtor, that these all definitions we have already seen, and they apply to whole of the part 3.
Sir, one doubt, sir.
हाँ बोलिए.
Sir, this the resolution process, there is no liquidation process here.
No, bankruptcy. Actually, there is either repayment in part 3, there is either repayment or bankruptcy.
That's all.
Yes.
Sir, then there is no financial creditors and operational creditors. There is
yes. I think you joined late. So
sir.
there is either debtor or creditor. So the distinction between financial and operational creditor disappears here.
Okay, sir. Thank you, sir.
This process is not applicable to the individuals just because so far it has not been notified, correct?
Yes. But we have to understand.
No, but
we have to read the provisions.
Is this process applicable to corporate guarantor?
Yes. So
against his
the
CRP
provisions, the insolvency and bankruptcy provisions regarding personal guarantors to a corporate debtor have already been specified. There are regulations.
But the same process.
Suppose today
the
you
one
want to
which we
file
are
an
discussing.
application for a fresh start process, you cannot file because there are no regulations, no forms, nothing.
But if individuals or firms have given guarantee to corporate person,
Yes.
So
Then
these
application
are the
can be filed
regulations.
in
These are the
NCLT. Yes.
sections applicable.
But even for fresh start, even for individual insolvency and bankruptcy, for which regulations have not yet come, rules have not yet come, even on those provisions, case study can be made. Because as per syllabus, they can make a case study. They are giving case studies on fast track, this fresh start.
Now, our question is for corporate person, individuals have given guarantee.
Yes. In case an individual has given
So
guarantee for a
those
company,
individuals,
then
this is the
regulations are
bankruptcy
there
procedure.
already.
Yes, sir. And this is the procedure.
Yes, this is the procedure. This is the procedure whether an individual has taken a loan or a guarantor has given a guarantee. So for
Correct.
both,
Same
same provisions are there.
qualifying debt, qualifying asset, all these
Yes,
things will apply to individuals
yes.
who stood as guarantor.
Yes.
Yes, sir. Thank you.
So this all we have already seen. This fresh start we had already seen 60, 20, 35. So now this insolvency resolution process 94. We'll study the basic provisions first, then we'll study the regulations. So we may take instead of one session, 2 sessions on this. But the basic idea is to understand the provisions rather than to rush through all these things. Section 94. So section 94 says application by debtor. Briefly, I've explained. So 94, application by debtor. Debtor to initiate insolvency resolution process. So a debtor who commits a default may apply either personally or through a RP. Similar is the case of fresh start. In fresh start also, we have seen that the debtor can apply either personally or through RP. So similarly here, so he may apply either personally or through RP, but in all cases, in case he applies personally, then adjudicating authority will write to IBBI for appointment of RP. And where the debtor is a partner of a firm, such debtor shall not apply unless all or majority of the partners of the firm file the application jointly. So in case it is a partnership firm and they want to apply for insolvency, so in that case, either all the partners or majority of the partners, they have to file the application jointly. And an application shall be submitted only in respect of debts which are not excluded debts. Excluded debts we have already seen, fine imposed by the court, etc., etc. So even if a discharge order is issued, so that will not operate as regards the excluded debts which have to be paid in any case. And a debtor shall not be entitled to make an application if he is an undischarged bankrupt. It means some bankruptcy proceedings are already undergoing. He is undergoing a fresh start process, undergoing an insolvency resolution process, or undergoing a bankruptcy process. And a debtor shall not be eligible to apply under subsection 1 if an application under this chapter has been admitted in respect of the debtor during the period of 12 months preceding the date of submission of the application under this section. So if an application has been admitted, so here you will find some difference from fresh start. So in case of individual insolvency, a debtor will not be able to apply under subsection 1 if some application has been admitted. But there the concept was different. As against this, if we see section 80. So section 80 says no previous fresh start order has been made, or a fresh start process is not subsisting against him. But here the wording is different. The wording is has been admitted. So in case it was admitted and even if withdrawn, then also he cannot apply within a period of 12 months. So there is a small difference if we see the provisions regarding section 80, subsection 82 F and G. So you have to compare this with, let me show you the section 80 also. So section 82F says a fresh start process is not subsisting. Not subsisting means there is nothing pending. So even if it was admitted and it was withdrawn, so it is not subsisting. But here it is somewhat different. Here the word is admitted and no previous fresh start has been, no previous fresh start order has been made. This is the wording of section 80 to F and G. And now let us read this wording. This says he shall not be eligible if an application has been admitted. And the application referred to in subsection 1 shall be in such form and manner and accompanied with such fees as may be prescribed. So rules have to come for this. 95. 95 says application by creditor. So 94, application by debtor, who may be an individual or a partnership firm, whether unregistered or registered. Section 95, application by creditor. So creditor also, but in creditor he can apply jointly also. So he may apply either by himself or jointly with other creditors or through a resolution professional. Like in case of CIRP, in part 2, we have seen that a financial creditor may apply either singly or jointly, but an operational creditor cannot make a joint application. But here, there is no concept of financial creditor or operational creditor. So in this case, the wording used is creditor. So creditor can apply either himself or jointly with other creditors or through an RP. And a creditor.
Under CIRP for financial creditors, the section says that they may apply jointly or singly. And there are judgments wherein financial creditor, if default occurs, then the other financial creditor also can apply. तो ऐसा क्या इस केस में भी है?
क्या मतलब, मैं समझा नहीं आपकी बात.
Sir, CIRP में, if the financial default has occurred, and for the financial creditor in respect of which default has occurred, he is not applied. The other, some other person is applied.
वो तो है, वो हाँ वहाँ हो सकता है. हाँ,
यहाँ पे क्या स्थिति है सर? अभी क्लैरिटी नहीं है क्या?
नहीं, यहाँ पर क्या बोलता है? यहाँ बोलता है either by himself or jointly with other creditors. तो ऐसा नहीं है कि किसी का डिफॉल्ट नहीं हो, वो अप्लाई नहीं कर पाएगा यहाँ पर. जैसे फाइनेंशियल क्रेडिटर में क्या है, सपोज देयर इज अ कंसोर्टियम ऑफ बैंक्स which is having 4 banks. Default has occurred only in respect of one bank, but the other banker can also apply. But here it is not so. Here, if a creditor has to apply, so he can either apply either by himself or jointly with other creditors. So here, if there is no default regarding a creditor, so then he cannot apply.
Section 7 में भी सब same wording दिया हुआ है.
है?
Section 7 में भी same wording है. A financial creditor either by himself or jointly with others. With other financial creditors.
नहीं, अरे समझो नहीं सर, आप बात नहीं समझे. देखो ऐसे है, वो सिर्फ फाइनेंशियल क्रेडिटर में, यहाँ तो फाइनेंशियल क्रेडिटर नहीं है ना. हियर द कॉन्सेप्ट इज, मतलब दैट कॉन्सेप्ट इज ब्लर्ड ना. भाई he may be an operational or financial creditor. Regarding operational creditor, he cannot apply jointly.
That is okay, right? But I'm talking about this concept of the same language is there in section 7 also and section 95 also. और section 7 में judgment है कि कोई और financial creditor भी आपके behalf पे apply कर सकता है, even if the default is not.
But here you cannot apply. Here you cannot apply. First of all, there has to be a default to trigger, and then creditor has to apply.
Creditor.
Huh?
Default for that specific creditor.
Yes, हाँ, बिल्कुल बिल्कुल. 95 में ऐसा नहीं अप्लाई कर पाएगा. 95 में ये है कि he can apply either by himself or jointly with other creditors. तो वहां पर क्या है, वहां देखो दो सेक्शन है, section 7 and section 9. 9 is different, 7 is different. In case of 9, there cannot be any joint application. But here we have to make a conjoint reading of section 7 and 9. और 95 में ऐसा कोई कॉन्सेप्ट नहीं है. आपका क्वेश्चन यही है कि अगर किसी क्रेडिटर का डिफॉल्ट नहीं हुआ तो whether he can apply or not, he cannot apply. A creditor may apply under subsection 1 in relation to any partnership debt owed to him for initiating an insolvency resolution process against any one or more partners of the firm. Suppose there is a partnership firm and there is a default by that partnership firm. Now a person who is to get money from that partnership firm, he wants to apply. So he can apply for the insolvency of any one or more partners of the firm, or he can apply for insolvency and bankruptcy of the firm. But both the processes have to be one by one. So first of all, insolvency, and then if repayment is not done, then bankruptcy. where an application has been made against one partner in a firm. So, and that process is also not automatic. Where an application has been made against one partner in a firm, any other application against another partner in the same firm shall be presented in and transferred to the adjudicating authority in which the first mentioned application is pending. Suppose one application was made and then thereafter another partnership, another application was made in the same firm, then it will be, those two applications will be clubbed. And such adjudicating authority may give such directions for consolidating the proceedings under the applications as it thinks fit. An application under subsection 1 shall be accompanied with details and documents relating to debts owed by the debtor to the creditor or creditors submitting the application for insolvency resolution process as on the date of application. The failure by the debtor to pay the debt within a period of 14 days of the service of the notice of demand. In case of CIRP, we have seen that under section 8, notice has to be given and the CD has to revert within a period of 10 days. So here the period of reversion is 14 days. Suppose the creditor first for moving the, yes, Vishwanath Patilji.
Sir, if application is made against one partner,
Yes.
is it that it is deemed to be that application is made against the firm or against all the partners?
Yes.
Because they are jointly and severally
Moratorium
liable.
applies to all the partners because in case of firm that we will see later, but
Okay.
once it is your choice. It is the creditor's choice whether he wants to move an application against any one or more partners of the firm or the firm, but it will operate against all partners of the firm.
Finally, everybody will be responsible.
Yes. Everybody will be roped in
Okay.
because their liability is joint and several. No?
Correct. Yeah.
The failure by the debtor to pay the debt within a period of 14 days. So in case of CIRP, the concept is of 10 days, but here the period of 14 days. Within 14 days, if the debtor doesn't revert, then an application can be filed. And relevant evidence. The creditor shall also provide a copy of the application to the debtor. So in case the creditor has moved an application to the adjudicating authority, he will also give a copy to the debtor because debtor may not come to know of this thing. And the application referred to in subsection 1 shall be in such form and manner and accompanied by such fees as may be prescribed. Then there is a concept of interim moratorium. So when an application is filed under section 95 by the debtor or section 95 by the creditor, interim moratorium shall commence on the date of application in relation to all the debts and shall cease to have effect on the date of admission of such application, because on the date of admission of application, moratorium starts and this interim moratorium ends. During interim moratorium period, any pending legal action or proceeding in respect of any debt shall be deemed to have been stayed. And the creditors of the debtor shall not initiate any legal action or proceeding in respect of any debt. So whosoever are the creditors, they have to lodge the claim here because there will be public announcement and all those things. Where the application has been made in relation to a firm, the interim moratorium under subsection 1 shall operate against all partners of the firm as on the date of application. So even if application has been made against one partner or one or more, suppose there are 4 partners, now the creditor has choice. He can move an application against one, he can move an application against 2, 3, 4 or the firm. And the provisions of subsection 1 shall not apply to such transactions as may be notified by the central government in consultation with any financial sector regulator. Then section 97, it talks of appointment. So if the application under section 94 or 95 is filed through RP, the adjudicating authority will direct the board within 7 days to confirm there are no disciplinary proceedings. So 97.2 is an important section. 7.2 means 7. So within 7 days, adjudicating authority will direct the board, and within 7 days, board will revert. But normally, in all the other cases, the period is 7 days plus 10 days. So here, this is the only section 97.2 where the period is 7 plus 7. So you can easily remember 97.2, 7, 2 times 7. The board shall, within 7 days of the receipt of directions, communicate to the adjudicating authority, either confirming or rejected. Where an application under 94 or 95 is filed by the debtor or creditor himself and not through RP, the adjudicating authority shall direct the board within 7 days of filing the application to nominate, and board will revert within 10 days. And the adjudicating authority shall by order appoint the RP recommended by the board or as nominated by the board. and a resolution professional shall provide a copy of the application for insolvency resolution process. So this resolution professional who was not appointed initially, but now he has been appointed by the adjudicating authority, he will also be provided with a copy because he doesn't have the copy. 98 talks of replacement. So in this case, the debtor or the creditor. So whenever the debtor or the creditor is of the opinion that RP is required to be placed, he may apply to the adjudicating authority. And then same provision, 7 days, 10 days. Without prejudice, the creditors may apply to the adjudicating authority for replacement of the RP where it has been decided in the meeting of the creditors to replace the resolution professional with a new resolution professional for implementation of the repayment plan. So even during repayment, they may appoint a new resolution professional. And then same procedure, 7 days, 10 days. On the basis of communication of the board, the adjudicating authority shall pass an order appointing a new resolution professional, and new will share the old resolution professional will share all the information with the new resolution professional. Simple. 99. Submission of report. So this is an important section where this RP has been given a great responsibility. As in case of fresh start we saw yesterday, the resolution professional, he will examine the application in section 94, which is put by the debtor, or 95, which is put by the creditor, within 10 days of his appointment. And he will submit a report to the adjudicating authority recommending for approval or rejection. In both cases, he has to give reasons in writing. Where the application has been filed under section 95, the resolution professional may require the debtor to prove a repayment of debt claimed as unpaid by the creditor by furnishing same. Like in case of section 9 application, when the operational creditor moves an application by giving notice of 10 days under section 8. So similarly, here the creditor has to give 14 days notice before filing an application. And in case application has been filed under section 95, that means by the creditor, so RP will require to prove the payment. So here, some of the roles of adjudicating authority have been consumed by the RP. RP has been delegated this responsibility that you check these basic things, whether payment has been made, etc., etc. Otherwise, in section 9, the adjudicating authority checks all these things. And where the debt for which an application has been filed by a creditor is registered with the information utility, the debtor shall not be entitled to dispute the validity of such debt. Because as we know, in case of information utility, there is only one information utility as of now, National E-Governance Services Limited, wherein information is fed, one party gives the information and it is verified by from the other party. Suppose a banker has given a loan. Now banks have entered into agreement with NESL that okay, whenever there is any new loan, whenever there is any payment of loan, whenever there is any creation of charge, whenever there is satisfaction of charge, so they will inform all these things to NESL. And suppose a banker says that okay, this PAN number has taken a loan. Now a mail will be shot to the other person, to the person who has availed the loan. Okay, this banker has informed that you have taken a loan. You confirm it or not? Now there can be three options. Number one, he may keep mum. Okay, he will not revert. He will not reply at all. So then case it will be red, yellow marked. In case he rebuts, I have not taken any loan, the red mark. He confirms that okay, yes, I have taken loan, green marking. So green, yellow, and red. And no information is fed into the information utility unless it is counter verified by the opposite party. So that is why there is a concept that he cannot dispute the validity of this debt in case it is registered with the information utility. For the purpose of examining an application, the resolution professional may seek for such further information naturally because he has to give his report. Taken? Who, in the opinion of the resolution professional, may provide such information. So similar provision, we saw similar provision in case of fresh start also. The person from whom such information, he shall furnish such information within 7 days. I think same is the period in case of fresh start also. And the resolution professional shall examine the application and ascertain that application is satisfied, applicant has given information, and he may recommend acceptance or rejection. And where a resolution professional finds that debtor is eligible for a fresh start, the resolution professional shall submit a report recommending that the application by the debtor shall be treated as an application under section 81 because the minimum default is same. Minimum default is 1000 for fresh start also and for this individual insolvency also. So here, if someone has moved an application, and the RP feels that the debtor is eligible for fresh start, then the RP will submit a report that this should be treated as an application under fresh start. But the wording used is application by the debtor under section 94. The resolution professional shall record the reasons for recommending the acceptance or rejection of the application. And the resolution professional shall give a copy of the report to the debtor or the creditor as the case may be. Okay. In case debtor has moved an application, creditor will be provided with a copy. In case creditor has moved an application, debtor will be provided with a copy. Admission or rejection of application. Now, the report has been submitted to the adjudicating authority, and adjudicating authority, as normally, it takes 14 days period. And where the adjudicating authority admits an application, it may, on the request of the RP, issue instructions for the purpose of conducting negotiations between the debtor and creditor and for arriving at a repayment plan. This is an important section. So there is a concept of conducting negotiations between the debtor and the creditor. So here also the adjudicating authority may issue instructions for the purpose of conducting negotiations. अरे भाई मेरा क्यों time waste कर रहे हो? दोनों आपस में ले दे लो जो पैसा देना लेना, ठीक है? The adjudicating authority shall provide a copy of the order passed under subsection 1 along with the report of the RP and application referred to 94 and 95 as the case may be to the creditors within 7 days from the date of the said order. Okay. Why? To the creditors. To the creditors means to all the creditors. Suppose one creditor has moved an application. Okay. And now the other creditors are not aware about this thing. So all the creditors will be informed. If the application referred to in section 94 or 95, as the case may be, is rejected by the adjudicating authority on the basis of a report or that the application was made with the intention to defraud his creditors or the RP, the order shall record that the creditor is entitled to file for a bankruptcy. So if there was a fraudulent intention by the debtor to file for insolvency, so in that case, the application may be rejected and the creditor will be entitled to file for a bankruptcy. Moratorium. And both the applications by the debtor or the creditor, they may be rejected. Moratorium. Where the application is admitted under section 100, moratorium will commence in relation to all the debts and shall cease to effect at the end of 180 days, same as in case of fresh start, beginning with the date of admission and ending on the date of passing the order on the repayment plan. And during moratorium period, any legal pending legal action or proceeding in respect of any debt shall be deemed to have been stayed, and the creditors shall not initiate any legal action or legal proceeding in respect of any debt. The debtors will not transfer, alienate, encumber, or dispose of any of the assets or his legal right or beneficial interest. Now you see, you compare this moratorium effect with interim moratorium. Because interim moratorium is given in section 96. So if we compare section 96 with 101, in 96 interim moratorium is there. And during interim moratorium, there is no concept of this alienation of assets. The traitor shall not transfer. So this condition is not there. Only two conditions are there, that during interim moratorium period, any legal action shall be deemed to have been stayed, and the creditors of the debtor shall not initiate any legal action or proceeding. So there is a difference. This point number C, is not there in case of interim moratorium. Why? Because after interim moratorium, this application may be admitted or rejected. So there are both the scenarios. So debtor cannot be put under some compulsion. But here, once this application has been admitted, he will not be able to transfer. Where an order admitting the application under section 96 has been made in relation to a firm, the moratorium will operate against all the partners of the firm. Okay.
So section 100 में admission के केस में there is a subsection 2 जहाँ पे negotiation की बात करता है.
हाँ.
So this negotiation इसको थोड़ा सा समझाएं सर क्या है?
नहीं, देखिए ऐसा है ना भाई, now this application has been admitted. ठीक है, इसमें क्या बोलता है, on the request of the RP. तो adjudicating authority, because RP has been roped in for all the activities. ठीक है, RP नहीं वो अपना सारा एग्जामिन वगैरह किया है, तो अगर उनको लगता है, जैसे वहां पर क्या है, CIRP में कॉन्सेप्ट है ना वो अपना रीपेमेंट वाला, इवन आफ्टर एडमिशन देयर इज विड्रॉल प्रोविजन, सेक्शन 12A. 12A का पर्पस क्या है, 12 अगर पेमेंट हो गया तो व्हाई टू ड्रैग दिस प्रोसीडिंग्स, है कि नहीं? तो यहाँ पर अगर अल्टीमेट पर्पस क्या है, अल्टीमेट पर्पस तो पैसे ही लेना है. अगर इफ देयर इज एनी पॉसिबिलिटी ऑफ नेगोशिएशन तो यहीं पर ही खत्म कर दो, क्यों ज्यादा चक्रों में पड़ो. ठीक है,
एडमिशन करने के बाद में, राइट?
बिल्कुल. और क्या भाई, एडमिशन ही नहीं हुआ तो बात ही खत्म हो गई ना, फिर तो रिजेक्ट ही हो गई, खत्म बात. फिर तो एडमिशन के बाद ही होगा ना ये. एडमिशन के बाद में क्या बोलता है, ऑन द रिक्वेस्ट ऑफ द आरपी. बिकॉज आरपी क्या होगा, मान लो एप्लीकेशन, सपोज एप्लीकेशन हैज मूव्ड एट द इंस्टेंस ऑफ द डेटर और क्रेडिटर, ठीक है ना, तो उनको नेचुरली उसको आरपी को भी लगेगा भाई देयर आर चांसेस ऑफ, तो इसीलिए वही रिक्वेस्ट करेगा ना एडजुडिकेटिंग अथॉरिटी को. ही विल इशू इंस्ट्रक्शंस, एडजुडिकेटिंग अथॉरिटी विल इशू इंस्ट्रक्शंस ऑन द रिक्वेस्ट ऑफ द आरपी. अगर हो जाएगा तो पूरा प्रोसेस खींचने की जरूरत क्या है, अभी तो पब्लिक अनाउंसमेंट नहीं हुआ ना यहाँ.
Sir, during interim moratorium,
हाँ.
debtor can alienate the property.
Yes. बिकॉज इंटरिम मोरेटोरियम में क्या हो रहा है भाई, अभी तो एप्लीकेशन जो है ना, इट इज एट फाइलिंग स्टेज ओनली. अभी तो एडमिट तो हुआ नहीं है, तो पता नहीं एडमिट होगा नहीं होगा.
No, if he gets the information and if he alienates.
वो देखो ऐसा, वो PUFE ट्रांजैक्शंस वाले प्रोविजन हम पढ़ेंगे बाद में, वो पढ़ेंगे.
Okay.
हाँ हाँ, वो वहां तो है ही ना उसका, वो तो पीरियड है, फिर रिलेटेड पार्टी को किया, किसको किया, वो सब है. And the provisions of this section shall not apply to such now public notice. Adjudicating authority will issue a public notice within 7 days of passing the order. वर्ड तो लिखा है shall issue adjudicating authority, जैसे adjudicating authority नहीं देना है, लेकिन अगर हम regulations पढ़ें regarding personal guarantors तो वो ये है कि it will cause to have issued. ठीक है ना, RP ही issue करता है normally public notice within 7 days of passing of the order. Inviting claims, ठीक है, जैसे वहां पर 3 days है CIRP में, liquidation में शायद 5 days है, यहाँ पर 7 days है. ठीक है, तो दे विल इनवाइट क्लेम्स फ्रॉम ऑल द क्रेडिटर्स विद इन 21 डेज. जैसे CIRP में कितना है 14 डेज है, लिक्विडेशन में 30 डेज है, हियर इट इज 21 डेज. तो सारा हमें मिला जुला के पढ़ना है इसको. एंड द नोटिस अंडर सबसेक्शन 1 शैल इंक्लूड डिटेल्स ऑफ द ऑर्डर admitting the application, particulars of the RP with whom claims are to be registered, and the last date for submission of claims. Notice shall be published in at least one English and one vernacular newspaper. Where the debtor resides, कहां पर इशू करना है, जहां पर डेटर रिजाइड करता है. डेटर रिजाइड मतलब या तो इंडिविजुअल या पार्टनरशिप फर्म का फर्म का पार्टनर होगा. ठीक है ना, एफिक्स्ड इन दी प्रीमिसेस ऑफ दी. अब आप कहोगे जी 4 पार्टनर है, 4 पार्टनर अलग अलग स्टेट्स में रहते हैं, तो क्या होगा भैया, ऐसा है कि अगर मान लो 4 के अगेंस्ट में भी, या तो जब इनिशिएट होगी या तो एक के अगेंस्ट में होगी या एक से ज्यादा के अगेंस्ट में होगी. बाद में अगर सपोज इट इज इनिशिएटेड एट अ लेटर डेट तो वहां पर वो क्लब हो जाएगी. ठीक है ना, तो जो डेटर रिजाइड्स है वो बेसिकली वही वो पार्टनरशिप फर्म वाला ही आ जाएगा उसमें भी, या पार्टनर का जो रेजिडेंस होगा वो आ जाएगा. Affixed in the premises of the adjudicating authority and placed on the website of the adjudicating authority. तो इसका वैसे कॉमन सेंस ये बनता है कि फर्म के केस में वो जो फर्म का जहां पर ऑफिस होगा वहीं पर ही वो करेंगे. रजिस्टरिंग ऑफ क्लेम्स बाय क्रेडिटर. The creditor will register, यहाँ पर वर्ड है रजिस्टर. कई sometimes questions are being set on this word only कि ये रजिस्टर वर्ड है, यहाँ पर लॉज नहीं है या फाइल नहीं है, वर्ड है रजिस्टर। तो इसी तरह से 4 ऑप्शन दे देगा आपको। द क्रेडिटर विल रजिस्टर क्लेम्स, द रजिस्टर विल फाइल क्लेम्स, इस तरह द रजिस्टर विल लॉज क्लेम्स, विच ऑफ द ऑप्शंस इज करेक्ट, इस तरह से। हाँ पूछिए somebody raised hand।
Yes, sir, myself.
हाँ पूछिए।
Affix, you see, the notice shall be published at least one English and one vernacular which is in circulation in the state where the data resides.
हाँ
B, affixed to the premises of adjudicating authority.
Hmm.
C, placed on the website of the adjudicating authority. This
Hmm.
is adjudicating authority means NCLT.
एक मिनट
DRT.
No, in case of CARP, it is NCLT. Now,
It is in DRT.
DRT.
For individuals and partnerships from the.
no, sir,
DRT.
abhi it is not notified. It is not notified. I
हाँ
can
विलियम राजू
understand.
जी, ऐसा है, अभी provisions regarding individuals have not yet been notified, so only provisions regarding personal guarantors to corporate debtors
Sir,
have been
personal
notified.
guarantors are notified
हाँ
and cases are filed in NCLT because the
Yes,
CARP
yes,
process
yes.
was
वो
now
हम
the
अभी
question.
अभी अभी पूरी स्टोरी कंप्लीट नहीं हुआ, अभी वो भी आएंगे, we will come to that।
नहीं क्या कर रहे सर, adjudicating authority NCLT के प्लेस में ऐसा कुछ सुविधा नहीं है।
हाँ
Their website में they are not posting anything. In case of personal guarantor, in case of the premises,
तो वो तो
they
है
are
ही,
not-
अभी ऐसा है ना भाई, दैट इज गवर्न्ड बाय सेक्शन 60 बेसिकली। जो पर्सनल गारंटर्स टू कॉर्पोरेट डेटर है ना, वहां पर डीआरटी में एप्लीकेशन भी नहीं फाइल होता। यहाँ तो हम पढ़ रहे हैं, हम क्या पढ़ रहे हैं यहाँ पर, वी आर रीडिंग भाई एप्लीकेशन विल बी फाइल्ड विद डीआरटी, एडजुडिकेटिंग अथॉरिटी इज डीआरटी, बट इन केस ऑफ पर्सनल गारंटर्स टू कॉर्पोरेट डेटर द एडजुडिकेटिंग अथॉरिटी इज एनसीएलटी। वो सेक्शन 60 से गवर्न होता है ना। अभी ऐसा है, प्रोविजंस ऑफ द कोड वी हैव टू रीड। अभी चाहे उसमें रेगुलेशंस नहीं आए हैं, रूल्स नहीं आए हैं, फॉर्म्स नहीं आए हैं, बट स्टिल वी हैव टू रीड दीज रेगुलेशंस एज इट इज। इसको हमें ऐसा ही पढ़ना है। हम इसको एडजुडिकेटिंग अथॉरिटी को जो है वो अभी सपोज क्वेश्चन कम्स कि हु इज द एडजुडिकेटिंग अथॉरिटी फॉर इंडिविजुअल्स इन पार्टनरशिप फर्म, द आंसर विल बी एनसीएलटी। एंड इफ द क्वेश्चन कम्स that who is the adjudicating authority in case of personal guarantor to corporate debtor, then the answer will be the NCLT. Registering of claims by creditor. So the word I was putting stress on this word, it shall register. Question has been set on this. The creditor shall register claims with the resolution provisional. So each and every word you have to see by sending details of the claims by way of electronic communication or through courier, speed post or registered letter. So even through registered letter, claim can be filed. In addition to the claims referred in subsection 1, the creditor shall provide to the RP personal information and such particulars as may be prescribed.
अच्छा सर, sorry to interrupt sir.
नहीं पूछिए।
Actually, there may be cases. Suppose there is a listed company and they have supplied and sold their goods to the MSME or state electricity boards, right?
ठीक है।
और उसमें उन्होंने 2 साल 3 साल नहीं चुकाया, कुछ न कुछ उसमें कमी निकाल दिया कि आपके प्रोडक्ट में क्वालिटी थोड़ी सी इशू थी, इंफीरियर था, एंड
ठीक है।
तो इसमें क्या कैन बी गो फॉर दिस प्रोसेस?
नहीं देखिए, ऐसा है ना, अगर वो कॉर्पोरेट फॉर्म में है, if the person to whom you have supplied the goods is a company, then you will be governed by part 2. वो तो part 2 में है ना। Now we are reading part 3. Part 3 is if you have supplied, if there is a default by an individual or a partnership firm. In case the default is by a corporate person, company, LLP, वो सारे वो वहां पर आएंगे पार्ट 2।
अच्छा, स्टेट इलेक्ट्रिसिटी बोर्ड्स हैं, PSUs हैं, ये भी आ जाएंगे?
वो सब वो पार्ट 2 में आते हैं, वो सब पार्ट 2 में आते हैं, बिकॉज दे आर स्टैट्यूटरी कॉर्पोरेशंस, वो सब पार्ट 2 में आते हैं।
तो वी कैन फाइल इंसॉल्वेंसी रेजोल्यूशन
नहीं, इंसॉल्वेंसी, हाँ, CIRP, यस, CIRP एंड देन लिक्विडेशन।
तो ये तो सर करोड़ों अरबों का ये दबा के बैठे हुए हैं सब, ये सब तो पैसे ये लोग। तो इनके
नहीं, देखिए
लिए
ऐसा
कोई सर
ऐसा
नहीं फाइल
है,
करता?
ऐसा, although this question is not relevant, but let me answer. Recently, there was a petition admitted against National Textile Corporation. So they were not paying to one of the creditors, one of the operational creditors who had supplied goods. Then he filed a petition. That petition was admitted by NCLT. But then they made the payment, and then they approached the NCLT that okay, he's withdrawing the application, the operational creditor is withdrawing the application, and NCLT allowed withdrawal of application. So provisions are same. वो तो देखो law तो सबके लिए same है, चाहे वो बड़ा हो छोटा हो. अब उसमें क्या हुआ, उसमें even this RP was appointed, application was admitted, RP was appointed, he made a public announcement also. और उसमें फिर उन्होंने कहा, एडवोकेट ने कहा जी इन्होंने गलत कर दिया, पब्लिक अनाउंसमेंट कर दिया. दे पुट प्रेशर ऑन द आरपी आल्सो, वहां जो उनका एडवोकेट था, एडवोकेट ऑफ नेशनल टैक्सेशन कॉर्पोरेशन. तो सब इस तरह से होता ही है. बट अल्टीमेटली दैट एप्लीकेशन वाज अलाउड टू बी विथड्रॉन, क्योंकि पर्पस तो क्या है, पर्पस तो ये नहीं है ना कि टू ड्रैग इनटू अननेसेसरी कंट्रोवर्सीज. वो तो बड़ा हो छोटा हो उससे कोई फर्क नहीं पड़ता, किसी को भी हो सकता है. वो तो यू हैव टू रीड द प्रोविजन सेम फॉर ऑल द पर्संस, चाहे वो
ओके
एक लाख की कंपनी हो, चाहे 100,000 करोड़ की कंपनी हो, कोई भी हो सकती है.
नहीं सर, अभी मैं कुछ कंपनियों को जानता हूँ.
अभी ऐसा है गुप्ता जी, ये ना बाद में बातें कर
Okay,
लेंगे, और आप मेरे से अलग से बात कर लेना. अदरवाइज क्या होगा, यहाँ का फ्लो जो है ना ये डिसरप्ट हो जाएगा, है कि नहीं.
ओके सर.
इस फ्लो से
Okay,
उसका कोई मतलब नहीं है, आप जो क्वेश्चन कर रहे हो ना. बट इन ब्रीफ आई हैव एक्सप्लेन टू यू, बाकी डिटेल में बात अलग से कर लेंगे, वो ज्यादा अच्छा रहेगा, है ना. अदरवाइज ये वाला
Section
छूट जाएगा.
95, section
थैंक यू सर, थैंक यू
95,
सर.
हाँ,
section 95, there is no concept of dispute. जैसे कि
भाई, हाँ
जैसे कि ऑपरेशनल क्रेडिटर्स में है,
हाँ हाँ,
यहाँ कॉन्सेप्ट ऑफ डिस्प्यूट नहीं है. डिस्प्यूट इज परसिस्टिंग, सो इट वोंट बी.
नहीं एक मिनट मैं आपको सेक्शन दिखाता हूँ. उसमें क्या है, आरपी क्या पूछता है उससे, ये देखो, वो मैं आपको वहां दिखाता हूँ. ये जैसे 90, इसमें वो जहां इलेक्ट्रॉनिक ट्रांसफर की बात करता ना, वो एक मिनट, ये यहां पर बात करता है. क्या बात करता है, जब एक सपोज एन एप्लीकेशन हैज बीन फाइल्ड बाय एन क्रेडिटर, ठीक है ना, उससे क्या पूछेगा आरपी, आरपी पूछेगा कि भाई कोई इलेक्ट्रॉनिक ट्रांसफर मिला आपको अनपेड अमाउंट का, या एविडेंस ऑफ एनकैशमेंट ऑफ चेक, या साइंड एक्नॉलेजमेंट बाय द क्रेडिटर एक्सेप्टिंग रिसिप्ट ऑफ ड्यूज. ठीक है, तो बस यही है, इतनी ही चीजें हैं इसमें. तो बेसिकली ये है, अगर पेमेंट आपको नहीं मिला तो यू कैन फाइल एन एप्लीकेशन.
डिस्प्यूट का कॉन्सेप्ट नहीं है
ना, डिस्प्यूट का कॉन्सेप्ट यहाँ नहीं है, क्यों, मिनिमम डिफॉल्ट ही बहुत कम है ना इसमें.
हाँ जी, हाँ जी, राइट.
तो ये इसको हमें 99 से देखना है. 99(2) में अगर कुछ है तो ठीक, अगर पेमेंट हो गया तो देन एप्लीकेशन कैन नॉट बी फाइल्ड, पेमेंट नहीं हुआ तो हो सकती है. अब इसी के अगेंस्ट में यू कैन काउंटर चेक इट विद सेक्शन 8. अब सेक्शन 8 भी खोल लेते हैं एक बारी. सेक्शन 8 में क्या बोलता है, सेक्शन 8 में फिर वो बात करता है उसकी एग्जिस्टेंस ऑफ ए डिस्प्यूट,
डिस्प्यूट
है ना. तो वो जो वर्ड है एग्जिस्टेंस ऑफ डिस्प्यूट, ये नहीं है यहाँ पर. यहाँ पर क्या कह रहा है, भाई 14 दिन के अंदर आपको पेमेंट करनी है, अगर पेमेंट नहीं करी आपने तो फिर हो जाएगी एप्लीकेशन फाइल. बाकी ऐसा वही बताया ना, अभी रेगुलेशंस तो आए नहीं है इसके, जब आएंगे तो और डिटेल में आएगा.
अभी तो इवॉल्व करेगा सर.
हाँ हाँ. अच्छा, ये कहाँ पहुंच गए थे हम, ये यहाँ 103, रजिस्टरिंग ऑफ क्लेम्स बाय द क्रेडिटर. सो क्रेडिटर विल रजिस्टर द क्लेम, दे शैल रजिस्टर द क्लेम्स. अच्छा, 104, यहाँ पर there is a concept of list of creditors. So RP will prepare the list of creditors on the basis of information disclosed, claims received, and the resolution professional shall prepare the list mentioned in subsection 1 within 30 days from the date of the notice. तो जो date of notice है उससे ये 30 days के अंदर ये लिस्ट तैयार करेगा. ठीक है. रीपेमेंट प्लान, The debtor shall prepare in consultation with the RP a repayment plan containing a proposal to the creditor for restructuring of his debts or affairs. भाई ठीक है, he is not able to pay, तो वो बोलेगा भाई मैं अभी नहीं दे सकता, तो मेरा डेट को रिस्ट्रक्चर कर दो, ठीक है ना, I'll pay. He will give a repayment plan, भाई मैं 1 साल में दूंगा, 2 साल में दूंगा, इस तरह से he will say things like that. Repayment plan may authorize or require the resolution professional to carry on the debtor's business or trade on his behalf on his name. ठीक है. So if the debtor is running any business, कोई सिनेमा हॉल है, कोई फर्म है, पार्टनरशिप फर्म है, ठीक है, कोई ट्रेडिंग फर्म है, तो ये आरपी कैन कैरी ऑन द डेटर्स बिजनेस, ठीक है, और रियलाइज द एसेट्स ऑफ द डेटर और एडमिनिस्टर और डिस्पोज ऑफ एनी फंड्स ऑफ द डेटर, समथिंग सिमिलर टू आरपी. जैसे आरपी आल्सो कैरीज ऑन द बिजनेस ऑन बिहाफ ऑफ द डेटर, सो सिमिलर इज द कंडीशन हियर. And repayment plan shall include the following, namely justification for preparation of such repayment plan and reasons on the basis of which the creditors may agree upon the plan. Okay. So this repayment plan, it will contain justification for preparation and the reasons on the basis of which the creditors may agree upon the plan and provision for payment of fees to the RP. यहाँ पर उसकी फीस भी पेमेंट करनी है आरपी की, तो ये रीपेमेंट प्लान के अंदर ही दिया रहता है कि उसकी फीस कैसे पेमेंट होगी, ठीक है. एंड सच अदर मैटर सच में
सर ये 102
हाँ
100 सबसेक्शन 2 में जो रीपेमेंट प्लान की बात करी गई है,
हाँ
एडमिशन एंड रिजेक्शन के बाद में the adjudicating authority admits an application and it may on the request of the RP issue instructions. तो ये इस रीपेमेंट प्लान के लिए किया गया, but not in my opinion not for the purpose of negotiation, for the withdrawal, क्योंकि withdrawal की तो बात ही नहीं हुई यहाँ पे अभी तक किसी में. और
नहीं विड्रॉल की बात नहीं है, वो देखो
स्पेसिफिकली उसने बोला for the purpose of,
हाँ हाँ वो कह रहे हैं ना, फॉर द पर्पस ऑफ कंडक्टिंग नेगोशिएशंस बिटवीन द डेटर एंड क्रेडिटर एंड फॉर अराइविंग एट अ रीपेमेंट प्लान. रीपेमेंट प्लान की बात ही हो रही है बेसिकली. भाई कैसे कैसे आप करोगे उस वो ऑर्डर में के अंदर लिख दिया जाएगा. बेसिकली क्या है देखो, सेक्शन 100 क्या है, सेक्शन एट द एंड ऑफ द सेक्शन 100 उसको ही हैज टू राइट एन ऑर्डर. वो ऑर्डर के अंदर ही लिख देगा कि भाई आरपी रिक्वेस्टेड एंड नेगोशिएशंस आर गोइंग ऑन एंड दे विल सून अराइव एट रीपेमेंट प्लान, ऐसे करके ये है इसमें. कोई एंड रिजल्ट यहां पर नहीं देना है अभी, बट ये है कि फॉर द पर्पस ऑफ कंडक्टिंग नेगोशिएशंस, तो समथिंग लाइक आर्बिट्रेशन ऐसा समझ लो आप. क्योंकि इवन ड्यूरिंग रीपेमेंट भी क्या है, आरपी की रिस्पॉन्सिबिलिटी तो है ही ना. आरपी इज देयर एट एवरी प्लेस, तो इसके लिए अगर नेगोशिएशन उनको करना है प्राइवेटली तो वो नेगोशिएशन कर लो, कुछ नेगोशिएशन करके देन दे विल कम टू द एडजुडिकेटिंग अथॉरिटी, भाई हमारा हो गया नेगोशिएशन, हम विड्रा करते हैं अपनी एप्लीकेशन. अच्छा, report of the resolution professional on repayment plan. The RP shall submit the resolution plan under section 105 along with his report on such plan to the adjudicating authority within a period of 21 days from the last date of submission of claims. ठीक है. And the report shall include that the repayment plan is in compliance. जैसे वहां section 32H वाला होता है clause in case of CIRP. So similar is the condition here. यहाँ repayment plan is in compliance with the provisions of any law. And repayment plan has a reasonable prospect of being approved and implemented. तो reasonable भी होना चाहिए, लगना चाहिए भाई हो जाएगा ऐसा. And there is a necessity of summoning a meeting of creditors if required. So meeting of creditors may or may not be summoned to consider the repayment plan, provided that where the RP recommends that a meeting of the creditors is not required to be summoned, reasons for the same shall be provided. Maybe there is only one creditor, ठीक है ना, एक ही क्रेडिटर है, मीटिंग क्या कॉल करनी, ठीक है. The report referred to in subsection 2 shall also specify the date on which and the time and place at which meeting should be held. ठीक है. और ये क्या डेट होगी? It shall not be less than 14 days and not more than 28 days from the date of submission of the report. ठीक है. And the resolution professional shall consider the convenience of creditors in fixing the date and venue of the मीटिंग ऑफ द क्रेडिटर. ठीक है भाई, कोई क्रेडिटर बोलता है मेरा कोई फेस्टिवल होता है उस दिन, पोंगल फेस्टिवल है, हम नहीं आ सकते, तो ठीक है वो दे विल कंसिडर द कन्वीनियंस. ठीक है, डेट और वेन्यू. क्योंकि ये थोड़ा क्लोज डोर अफेयर है ना, ज्यादा लंबा चौड़ा नहीं है. Summoning of the meeting of creditors. The resolution professional shall issue a notice calling the meeting of the creditors at least 14 days before the date fixed for such meeting. तो notice period इसमें कितना है? 14 days है. And the resolution professional shall send the notice of the meeting to the list of, जो उसने list prepare की है उसके basis. List कहाँ से prepare की? List उसने prepare की on the basis of,
Registered claims, sir.
हाँ, जो भी उसके पास claims आ गए. And the
Registered.
notice sent under subsection 1 shall state the address of the adjudicating authority to which the repayment plan and report of the RP on the repayment plan has been submitted and shall be accompanied by a copy of the repayment plan. ये जो मीटिंग हो रही है, मीटिंग में ये कॉपी ऑफ रीपेमेंट प्लान भी दी जाएगी. ठीक है. ए कॉपी ऑफ द स्टेटमेंट ऑफ अफेयर्स ऑफ द डेटर, उसके लिए फॉर्म है. A copy of the said report of the RP and forms for proxy voting. The proxy voting, including electronic proxy voting, shall take place in such manner and forms as may be specified. अभी आए नहीं. Conduct of meeting. ठीक है. अब इस मीटिंग में they may decide to approve, modify or reject the repayment plan. And the RP shall ensure that if modifications are suggested, consent of the debtor shall be obtained, because ultimately it is the debtor who has to make the payment. ठीक है ना. So for every modification, consent of the debtor is required. The resolution professional may, for a sufficient cause, adjourn the meeting of the creditors for a period of not more than 7 days at a time. ठीक है. जैसे CIRP में provisions है. CIRP में कितने दिन का adjournment हो सकता है at a time? हाँ जी, anyone?
24 hours. Next day.
Voting rights in meeting of creditors. A creditor shall be entitled to vote at every meeting of the creditors in respect of the repayment plan in accordance with voting share assigned to him. ठीक है. और voting share will be depending upon the जो भी amount उसका है. A creditor shall not be entitled to vote in respect of an unliquidated amount. ये हमने देख लिया. ठीक है. कोई liability crystallize नहीं हुई तो वो नहीं होगा. If his name does not appear in the list of creditors, yeah, he is an associate of the debtor. Associate का concept हमने शुरू कल ही पढ़ लिया था. Relative, basically related parties. Then rights of secured creditors. This is also important. जैसे वहाँ section 52 important है. We discussed it length section 52. Now is this section. Now the secured creditor, यहाँ पर थोड़ा सा difference है 52 से. इसमें क्या होता है? Secured creditor will be entitled to participate and vote in the meetings of the creditors. A secured creditor participating in the meeting of the creditors and voting in relation to the repayment plan shall forfeit his right to enforce the security during the period of the repayment plan in accordance with the terms of the repayment plan. तो अगर ये इसको creditors meeting में बुलाया, ठीक है, meeting of the creditors में, and is voting in relation to the repayment plan, तो then he cannot enforce his security. And if a secured creditor does not forfeit his right to enforce the security, he shall submit an affidavit to the resolution professional at the meeting. So this secured creditor may be having some secured debt and some unsecured debt also. So only for unsecured portion he can vote. So in case he doesn't forfeit his right to enforce security, so he will submit an affidavit to the RP that the right to vote is only in respect of unsecured portion of the debt and the estimated value of the unsecured part of the debt. And in case a secured creditor participates in the voting on the repayment plan by submitting an affidavit, the secured and unsecured parts of the debt shall be treated as separate debts. ठीक है. Same वहां पर भी होता है CIRP में भी, a person may be having financial debt and operational debt also. ठीक है ना. So both are considered separately. So here also secured and unsecured part to be considered separately. And the concurrence of the secured creditor shall be obtained if he doesn't participate in the voting on the repayment plan, but provisions of the repayment plan affect his right to enforce security. So in this case, the concurrence of the secured creditor shall be obtained if he doesn't participate in the voting or repayment plan, but provisions of the repayment plan affect his right to enforce the security. इसका मतलब क्या है? इसका मतलब ये है कि suppose the debtor वो बोलता है कि भाई ये जो सिक्योरिटी है ना, आई विल बी क्रिएटिंग चार्ज अगेंस्ट दिस सिक्योरिटी ऑल्सो, पेरी पैसू चार्ज. ठीक है भाई, एक सिक्योर्ड क्रेडिटर है बट द सिक्योरिटी वैल्यू इज मोर. सो इफ द प्रोविजन ऑफ द रीपेमेंट प्लान अफेक्ट हिज राइट टू एनफोर्स सिक्योरिटी, तो उस केस में क्या होगा? कंकरेंस उसकी चाहिए सिक्योर्ड क्रेडिटर. हमारे को इंटरिम फाइनेंस की कॉन्सेप्ट याद आ रही होगी Interim finance में क्या है? In case a debt is secured and you want to raise further debt, ठीक है, by creating a pari passu charge, then you have to leave twice the amount for that secured creditor, and above that you can obtain interim finance, creating security against that particular asset. So similar is the concept here. तो concurrence of the secured creditor shall be obtained. और वो वाला प्रोविजन कहां पर है, कोई बता सकता है मुझे? ये twice the amount वाला in case of CIRP? So this concept of interim finance is given in section 5, subsection 15. चलिए, explanation. For the purpose of this section, the period of the repayment plan means the period from the date of the order passed till the date on which the notice is given by the RP under section 117 or report submitted by the RP as the case may be.
सर ये twice the amount वाला concept जो है ये CIRP में कहाँ पे दिया हुआ है?
हाँ, तो वही तो मैं कह रहा था, ये ना आपको जो इंटरिम फाइनेंस है ना, आरपी जब इंटरिम फाइनेंस रेज करता है तो उसमें दिया हुआ है, आई थिंक मेरे हिसाब से ये होगा।
Sir, here there is no need, na, sir, interim finance. I think.
नहीं, इंटरिम फाइनेंस नहीं, रीपेमेंट प्लान में, रीपेमेंट प्लान में पैसे तो कहीं से लाएगा ना वो। देखो क्या बोल रहा है,
Source of funds, he has to give.
हाँ, concurrence of the secured creditor shall be obtained if he
Yes, sir.
doesn't participate, but provision for repayment plan affects his right to enforce security. Now, how his right can be affected? His right can be affected only if some similar charge is created against the property of which he is
Yes,
having
sir.
the security, no?
Sir, here percentage is there, sir, 66%, no, na, sir.
75%.
But based on the debt, outstanding
Yes,
debt,
yes,
sir.
yes.
Okay.
वो एवरेज मैं देख के बता दूंगा आपको।
तो वो section 20 बता रहे हैं।
हैं?
Section 20.
हाँ, शायद। हाँ, सेक्शन 20 में क्या बोलता है? सेक्शन 20 सबसेक्शन 2 सबसेक्शन सी, to raise interim finance provided that no security interest shall be created over any encumbered property of the corporate debtor without the prior consent of the creditor whose debt is secured over such encumbered property, provided that no prior consent of the creditor shall be required where the value of such property is not less than the amount equivalent to twice the amount of the debt. ठीक है, तो 22C. Now approval of a repayment plan by the creditors. So यहाँ पर अभी जो आप पूछ रहे थे वो उसका आंसर आ गया, more than 3/4. The repayment plan or any modification to the repayment plan shall be approved by a majority of more than 3/4. So you have to remember the exact wording. Exact wording is more than 3/4. So even exact 3/4 is not sufficient. More than 3/4 means something above 75 in value of the creditors present in person or by proxy and voting on the resolution in a meeting of the creditor. Approval of repayment plan by creditors. A report of meeting of the creditors on repayment plan. The RP will prepare a report of the meeting of the creditors on the repayment plan and this जैसा resolution plan में होता है 66%, यहाँ पर more than 3/4 है. And this report will contain whether repayment plan was approved or rejected, and if approved, the list of modifications, if any, the resolutions which were proposed at the meeting and decision on such resolutions, list of creditors who were present or represented at the meeting, and the voting records of each for all the meetings. So this report, for every meeting, he did not report to the adjudicating authority. So he is preparing a consolidated report of all the meetings in section 112. A list of creditors who were present or represented at the meeting and the voting records of each creditor for all meetings of the creditors and such other information as the RP thinks appropriate to make known to the adjudicating authority. 113. Notice of decisions taken at meeting. The resolution professional shall provide a copy of the report of the meeting of creditors prepared under section 99 to the debtor, creditors including those who were not present at the meeting, and the adjudicating authority. Then order of adjudicating authority on repayment plan. So adjudicating authority shall by an order either approve or reject the repayment plan based on the report of the meeting of creditors submitted by the RP. Provided that where a meeting is not summoned, the adjudicating authority shall pass an order on the basis of report prepared by the RP. And the order of the adjudicating authority approving the repayment plan may also provide for directions for implementing the repayment plan. And we have seen regarding the provisions of appointment of RP that even for repayment plan for implementation, separate RP may be appointed and the present RP may be replaced. Where the adjudicating authority is of the opinion that the repayment plan requires modification, it may require the resolution professional to reconvene a meeting of the creditors for reconsidering the repayment plan. So there could be a situation where the repayment plan was approved with more than 3/4 majority, but still the adjudicating authority feels that it requires modification. So it will direct the RP to reconvene the meeting of creditors. Effect of order of adjudicating authority on repayment plan. Where the adjudicating authority is approved, it will take effect as if proposed by the debtor in the meeting, binding on the creditors mentioned in the repayment plan and the debtor, and where the adjudicating authority rejects the debtor and the creditor shall be entitled to file an application for bankruptcy. So in this case, as per this part 3, application for insolvency can be moved by the debtor or creditor. Similarly, application for bankruptcy also can be moved either by the creditor or debtor. And a copy of the order passed by the adjudicating authority under subsection 2 shall be provided to the board for the purpose of recording an entry. 116, implementation and supervision of repayment plan. Something similar to implementation and supervision of resolution plan. The resolution professional appointed under section 97 or 98 shall supervise the implementation of the repayment plan. And the resolution professional may apply to the adjudicating authority for directions, if any, in relation to any particular matter arising under the repayment plan. And adjudicating authority may issue directions to the RP. Okay? Then completion of repayment plan. So when this plan is completed, repayment plan, the resolution professional shall within 14 days of the completion of the repayment plan forward to the persons who are bound by the repayment plan. Who are bound by the repayment plan? This we have already seen. It is binding on the creditors mentioned in the repayment plan and the debtor. Okay. And the adjudicating of the following documents. Notice that the repayment plan has been fully implemented and a copy of the report by the RP summarizing all receipts and payments made in pursuance of the repayment plan and extent of the implementation of such plan as compared with the repayment plan approved by the committee of the creditors. Now you might be wondering, in case of CIRP, this much elaboration is not given about the resolution plan, implementation of the resolution plan, but there are provisions regarding more clarity is there in case of liquidation. So in case of similarly here, like in liquidation, so it is something similar. In case of liquidation also, he is preparing a receipt and payment account. Yes, Patilji.
If the repayment plan takes 5 years to repay,
Huh?
so resolution RP will have to keep monitoring for 5 years.
Definitely he will be having his own fees. उसमें क्या है? It is up to the adjudicating authority to see कि भाई कितने देर में implement होना.
Because if the debt is more, then
हाँ, it may take. उसमें क्या? बिल्कुल हो सके. It may take. वो तो ऐसा है ना. This repayment plan has been approved by the creditors also with 3/4 majority. More than 3/4 majority have already approved. Na? Once more than 3/4 majority are agreeing, so any terms and conditions may be agreed. Adjudicating authority is also there. वो जो agree करेंगे उसना होगा. उसमें क्या है?
Okay.
And this report also, completion of repayment plan. So it is saying that once it is fully implemented, जैसे in case of liquidation, quarterly progress report is to be submitted. यहाँ ऐसा कुछ नहीं है. यहाँ ये है कि as soon as it is implemented, उसके within 14 days आपको देना है. बीच में कुछ नहीं देना है. You don't have to report in between. ठीक है? By monthly, quarterly, half yearly, annually, nothing like that. Once repayment plan is complete, then within 14 days. and a copy of the report by the RP summarizing all receipts and payments made in pursuance of the repayment plan and extent of the implementation of such plan as compared with the repayment plan approved by the meeting of the creditor. Sometimes the plan may not be implemented fully. So in that case, he will inform the extent of the implementation of the plan. The resolution professional may apply to the adjudicating authority to extend the time period in subsection 1 for such further period not exceeding 7 days. ये extension कौन सा है? ये 14 days वाला जो extension. So it may be extended by another 7 days. Repayment plan coming to end prematurely. Now the debtor agreed for a repayment plan. Creditors also agreed to it. Adjudicating authority also agreed to it, but he could not pay. Okay. A repayment plan shall be deemed to have come to an end prematurely if it has not been fully implemented in respect of all the persons. He made payment to some persons, but he could not pay to all. Okay. Within the period mentioned in the repayment plan. And where a repayment plan comes to an end prematurely, under this section, the RP will submit to the adjudicating authority, which will state the receipt and payment made in persons. कितना payment हो गया भाई 50%, 60%. ठीक है. Reasons for premature end of the repayment plan. Details of the creditors whose claims have not been fully satisfied. ठीक है. जिनका satisfy हो गया वो तो निकल गए, उसको जरूरत नहीं देने का, वो तो receipt and payment में आ जाएगा. ठीक है. But details of the creditors whose claims have not been fully satisfied. And the adjudicating authority shall pass an order on the basis of report submitted that the repayment plan has not been completely implemented. And the debtor or creditor, they are entitled to file for bankruptcy. Adjudicating authority shall forward to the persons bound by the repayment plan under section 115 a copy of the report submitted, order of the adjudicating authority, and it will be filed with the board also. Discharge order. Okay. On the basis of the repayment plan, the RP will apply to the adjudicating authority for a discharge order in relation to the debts mentioned in the repayment plan. Okay. And the adjudicating authority may pass such discharge order. The repayment plan may provide for early discharge, discharge on complete implementation of the repayment plan. Okay. Discharge order shall be forwarded to the board for the purpose of recording entries, and discharge order shall not discharge any other person from any liability in respect of his debt. ठीक है. जो order में लिखा है उतना ही होगा. Next. ये हो गया हमारा, यहां तक आ गए हम 120 तक. इंसॉल्वेंसी वाला कंप्लीट हो गया. अब हम ये देखते हैं एप्लीकेशन टू एडजुडिकेटिंग अथॉरिटी फॉर पर्सनल गारंटर्स टू कॉर्पोरेट डेटर. अभी देखिए, सपोज टुडे इफ यू वांट टू फाइल फॉर इंसॉल्वेंसी अगेंस्ट एन इंडिविजुअल और ए फर्म for a default of 1,000 rupees or more, you cannot file because there are no regulations. So regulations are there only for insolvency resolution process for personal guarantors to corporate debtor. So if there is an individual or if there is a partnership firm who has given a guarantee, so in that case, he will be considered to be a debtor, and the application can be filed under section 94 or 95. So personal guarantor, if he wants to file for his insolvency, he can file an application under section 94. If the creditor wants to file an application, then they can file an application under section 95. ठीक है. ये जो provisions पढ़ लिए हमने, ये वही apply होंगे वहां पर जो हमने debtor और creditor. Debtor यहाँ पर कौन बन गया? जो guarantor है वो debtor बन गया. ठीक है. So adjudicating authority.
Case study will study, sir. Case study, and this tomorrow will do it, sir. This is a personal guarantee. Case study, if it is there in the individual insolvency, will complete today. Tomorrow will do this personal guarantee, sir.
भाई ऐसा अभी इंडिविजुअल के ऊपर तो हमने कोई बनाई नहीं है, वो तो गारंटर के ऊपर ही है बेसिकली. क्योंकि क्या है, उस वो जो केस स्टडी बनेगी ना, उसमें तो क्या है, वो सिर्फ वही प्रोविजंस आएंगे जो हमने स्टडी किए हैं. व्हाटएवर प्रोविजंस वी हैव स्टडीड ना भाई, उसमें डिटेल है ही नहीं, कोई फॉर्म ही नहीं है, कोई कुछ नहीं है. समझ रहे हो आप? तो जितना आपने पढ़ा ना उसी के बेसिस पर ही कोई केस स्टडी बन सकता है. उसमें बना देंगे हम एक केस स्टडी.
ओके, ठीक है सर, ठीक है.
हाँ, थोड़ा सा देख लेते हैं इसको 5 मिनट.
So personal guarantor to corporate debtors को if they want to go for insolvency, they have to go under section 94, right?
Yes, बिल्कुल बिल्कुल बिल्कुल.
And even the banks want to drag them, they can drag them in 94 only.
नहीं 95 में आएगा ना वो 95 में एप्लीकेशन मूव.
95, right. 94, 95.
हाँ, वही 2 सेक्शन।
Okay.
वो यहाँ पर दे दिया। देखो गारंटर कौन है? गारंटर मीन्स ए डेटर who is a personal guarantor to a corporate debtor and in respect of whom guarantee has been invoked by the creditor and remains unpaid in full or part. So किसके अगेंस्ट में ये पिटीशन जा सकती है? अंडर 95। तो गारंटर मीन्स ए डेट जो जिसने पर्सनल गारंटी दी है किसको? कॉर्पोरेट डेटर को, ठीक है, और गारंटी इन्वोक हो गई एंड इट इज रिमेन्ड अनपेड इन फुल और पार्ट, ठीक है।
Sir, a case wherein the loan has been taken by a individual और उसका केस DRT में चल रहा है,
हाँ,
and there is a corporate guarantor who is a corporate to that individual.
मतलब
Mr. A ने लोन लिया,
इंडिविजुअल की गारंटी कंपनी ने दे रखी है।
हाँ जी, ABC लिमिटेड ने एक की गारंटी दे रखी है।
वो CIR पार्ट 2 में जाएगा वो फिर।
अच्छा,
वो
CIR
तो कंपनी की इंसॉल्वेंसी करनी है ना आपको।
हाँ,
वो तो आपको वो आप सेक्शन 5 में डेफिनेशन देखो ना, डेटर में क्या है? डेटर इंक्लूड्स कॉर्पोरेट गारंटर। तो गारंटर में भी एन इंडिविजुअल और ए कॉर्पोरेट पर्सन। इन केस द गारंटर इज ए कॉर्पोरेट पर्सन, वो पार्ट 2 में जाएगा। इन केस गारंटर इज एन इंडिविजुअल, पार्ट 3 में जाएगा।
ओके सर।
ये सेक्शन 5 में अगर आप जाओगे, सेक्शन 5 में आपको डेटर की डेफिनेशन पढ़ो। ये सेक्शन 3 में होगी। जैसे कॉर्पोरेट गारंटर आ गया। कॉर्पोरेट गारंटर कौन है? कॉर्पोरेट पर्सन हु इज श्योरिटी इन ए कॉन्ट्रैक्ट ऑफ गारंटी टू ए कॉर्पोरेट डेटर।
कॉर्पोरेट गारंटर तो एक कॉर्पोरेट पर्सन ही हो गया। इंडिविजुअल गारंटर्स कहाँ पे कवर होते हैं?
इंडिविजुअल गारंटर तो पार्ट 3 में कवर होगा ना भाई। देखो आपको क्या करना है, आपको देखना है एक्शन किसके अगेंस्ट में लेना है आपने, ठीक है। आप इंसॉल्वेंसी या CIR पे किसकी शुरू करना चाहते हैं? वो कौन है? इंडिविजुअल है या गारंटर है? अगर इंडिविजुअल है तो इट विल कवर्ड इन पार्ट 3। इफ इट इज ए कंपनी देन पार्ट 2, सिंपल। तो ये सारा इसमें जैसे वो आ गया अनएंकम्बर्ड पर्सनल ऑर्नामेंट, दिस वी हैव ऑल सीन, है ना। 1 लाख, वो 20 लाख, 10 लाख, ये सब हमने पढ़ लिया, कल ही भी पढ़ लिया था। यहाँ पर एप्लीकेशन दे दिया। गारंटर जो है 94 वाला जो गारंटर होगा वो एप्लीकेशन देगा फॉर्म A में, ठीक है, और जो क्रेडिटर होगा उसके लिए फॉर्म B है।
रेगुलेशंस देखना है क्या तुमको?
हाँ हाँ, ये एप्लीकेशन बाय क्रेडिटर, तो डिमांड नोटिस देना है फॉर्म B में और एप्लीकेशन आपकी होगी फॉर्म C में। फीस ऑफ 2000 रुपीज। और इसमें जो दोनों के लिए फीस 2000 रुपीज है, चाहे गारंट 94 का एप्लीकेशन हो या 95 की एप्लीकेशन। तो ठीक है, कल करते हैं इसको, केस स्टडीज इसकी, है ना।
ऐसा
हाँ, नहीं तो लंबा हो जाएगा। किसी का कोई क्वेश्चन है तो पूछ सकते हैं।